द सुप्रीम कोर्ट ऑफ इंडिया, भारत का सर्वोच्च न्यायालय, is the supreme judicial authority and the highest court of the Republic of India. It is the final court of appeal for all civil and criminal cases in India. It also has the power of judicial review. The Supreme Court, which consists of the Chief Justice of India and the maximum of fellow 33 judges, has extensive powers in the form of original, appellate, and advisory jurisdictions. Hello friends, welcome back to the channel. Know more about judiciary system in India. Before moving ahead, like, share and subscribe the channel, and don't forget to press the bell icon. As the apex constitutional court, it takes up appeals primarily against verdict of the high courts of various states and tribunals. As an advisory court, it hears matters which are referred by the President of India. Under judicial review, the court invalidates both normal laws as well as constitutional amendments as per the basic structure doctrine that it developed in the 1960s and the 1970s. It is required to safeguard the fundamental rights of citizen and settles legal disputes among the central government and various state governments. Its decisions are binding on other Indian courts as well as the union and the state government. As per the Article 142 of the Constitution, the court has the inherent jurisdiction to pass any order deemed necessary in the interest of complete justice, which becomes binding on the President to enforce. The Supreme Court replaced the Judicial Committee of the Privy Council as the highest court of appeal since 28 January 1950. 2 days after India was declared a republic with expansive authority to initiate actions and wield appellate jurisdictions over all courts and the ability to invalidate amendments to the Constitution, the Supreme Court of India is widely acknowledged as one of the most powerful Supreme Courts in the world. The Supreme Court of India was constituted as per Chapter 4 of Part 5 of the Constitution of India. The fourth chapter of the Indian Constitution is the Union Judiciary. Under this chapter, the Supreme Court of India is vested with all jurisdictions. As per Article 124, the Supreme Court of India has been constituted and established. As per Article 129, the Supreme Court is to be the court of record. As per Article 131, the original jurisdiction of the Supreme Court is authorized. As per Article 132, 133 and 134, appellate jurisdiction of the Supreme Court is authorized. Under Article 135, the federal court's power is given to the Supreme Court. Article 136 deals with the Supreme leave to appeal to the Supreme Court. Article 137 explains the review power of the Supreme Court. Article 138 deals with the enlargement of the jurisdictions of the Supreme Court. Article 139 deals with the conferment on the Supreme Court of powers to issue certain writs. Article 140 gives ancillary power to the Supreme Court. Article 141 of the Constitution gives the law-making power of the Supreme Court. The law declared by the Supreme Court is binding on all courts in the country. Eligibility of a judge of the Supreme Court. A citizen of India not exceeding 65-year age as per Article 124 of the Constitution, who has been a judge of one high court or more continuously for at least 5 years, an advocate there for at least 10 years, a distinguished jurist in the opinion of the President, power conferred by Clause 2 of Article 124 of the Constitution of India, is eligible to be recommended for appointment a judge of the Supreme Court. In 2007, Justice K.G. Balakrishnan became the first judge as well as the Chief Justice of India from the Dalit community. In 2010, Justice H. Kapadia, coming from a Parsi minority community, became the Chief Justice of India. In 2017, Justice Jagdish Singh Khehar became the first Sikh Chief Justice of India. Justice Indu Malhotra is the first and the only woman judge to be selected directly from the bars.